The General Data Protection Regulation, GDPR, is a landmark piece of legislation that transformed the way personal data is managed and protected across Europe. Enforced from the 25th of May 2018, GDPR replaced outdated data protection laws, aiming to create a unified standard that upholds individuals' privacy rights. Although GDPR originated as an EU regulation, it continues to have effect in the United Kingdom through the UK GDPR, as incorporated into domestic law following Brexit via the Data Protection Act 2018. At its core, GDPR is designed to give individuals more control over their personal information, ensuring that organizations handle data in a lawful, transparent, and secure manner. Whether you're a business owner, IT professional, or an employee handling personal records, understanding GDPR is not optional. It is a legal and ethical responsibility. Compliance requires more than just policies and tick-box exercises. It demands a cultural shift towards respecting data privacy at every level of operation. GDPR is far more than a regulatory formality. In a digital age where data drives services, commerce, and communication, the regulation aims to protect individuals from misuse, exploitation, and harm. Consumers entrust organizations with sensitive information, from addresses and medical records to online habits and payment details. GDPR exists to ensure that this trust is not violated. Non-compliance carries significant risks, not only in terms of financial penalties, which can reach up to £17.5 million or 4% of an organization's global turnover, whichever is higher, but also reputational damage. News of a breach or data mishandling can swiftly erode public confidence. However, GDPR is not just about penalties. It encourages best practice, transparency, and improved data management. By aligning with GDPR, organizations are better positioned to build trust with clients, streamline internal processes, and demonstrate corporate responsibility. As such, it serves both a protective and progressive role in today's data-centric environment. GDPR applies broadly and is not limited by geography or industry. It governs any organization, whether public or private, local or international, that processes personal data of individuals residing in the UK or EU. Importantly, this includes organizations located outside the UK or EU if they offer goods or services to, or monitor the behavior of, individuals within these regions. Under GDPR, there are two primary roles: data controllers and data processors. A controller determines the purposes and means of processing personal data, while a processor CTS on behalf of the controller, carrying out data operations under their instructions. Both parties have distinct legal obligations under the law. The regulation applies equally to large corporations and small charities, educational institutions, and healthcare providers. No organization is exempt simply due to its size or sector. If personal data is collected, stored, transmitted, or otherwise handled, GDPR compliance must be in place. Personal data under GDPR is defined broadly and includes any information that relates to an identified or identifiable natural person. This could be as straightforward as a name or email address, or more indirect like a location signal or cookie identifier. The scope of personal data also includes data that, when combined with other information, can lead to the identification of an individual. For example, a job title at a small company may not be sensitive on its own, but when linked with other data, it can easily reveal someone's identity. GDPR also classifies certain categories of information as special category data, which require additional protections. These include details about health, racial or ethnic origin, political opinions, religious beliefs, sexual orientation, and genetic or biometric data. Such information is particularly sensitive and can only be processed under strict conditions. The regulation demands that organizations carefully assess what data they hold, why they collect it, and how it is used. One of the cornerstones of GDPR is that personal data must not be processed unless there is a lawful basis for doing so. The regulation outlines 6 lawful bases: consent, contract, legal obligation, vital interests, public task, and legitimate interests. Each basis has its own requirements and implications. For example, consent must be freely given, specific, informed, and unambiguous, meaning that pre-ticked boxes or passive acceptance are not valid. If processing is necessary for the performance of a contract, such as delivering an online order, this too is a valid basis. Legal obligation covers situations where data must be processed to comply with a statutory duty, while vital interests relate to life or death scenarios, such as emergency medical care. Public task refers to functions carried out in the public interest or official authority, and legitimate interests offer a more flexible basis, provided individuals' rights and freedoms are not overridden. Choosing the correct basis is essential for lawful and ethical data handling. Data minimization is one of the fundamental principles of GDPR and is aimed at reducing unnecessary data collection. It requires that personal data collected must be adequate, relevant, and limited to what is necessary in relation to the purposes for which it is processed. This means organizations must not collect more information than they actually need, nor retain it longer than required. For example, collecting someone's date of birth may be essential for verifying age-related eligibility, but asking for unrelated information like marital status in that context would not comply with data minimization. By adopting this principle, organizations not only reduce their legal risk, but also limit the potential impact of data breaches. Holding less data means there is less to lose if security is compromised. In practice, this requires a thoughtful approach to designing forms, setting up data systems, and defining retention periods. Staff should be trained to question whether each piece of data collected serves a clear, lawful purpose. GDPR places a heavy emphasis on accountability, requiring organizations to demonstrate their compliance proactively. It is no longer enough to simply declare compliance. Documented evidence is needed. This includes maintaining records of processing activities, implementing data protection policies, conducting regular training, and performing data protection impact assessments, DPIAs, where necessary. The regulation also requires organizations to build privacy into their systems and processes by default, a concept known as privacy by design and by default. Governance structures must support these efforts, often through the appointment of a data protection officer, DPO, in certain circumstances. The DPO is tasked with overseeing data protection strategy, monitoring compliance, and serving as a contact point for supervisory authorities. Accountability extends to third-party vendors and service providers, who must also comply with GDPR requirements. Contracts should clearly define data responsibilities, and due diligence should be undertaken before any personal data is shared externally. Strong governance reduces risk and ensures consistent application of GDPR principles across the organization. GDPR enhances individual rights in significant ways, granting data subjects more power and control over their personal information. These rights include the right to be informed, the right of access, the right to rectification, the right to erasure, also known as the right to be forgotten, the right to restrict processing, the right to data portability, and the right to object. Individuals also have rights in relation to automated decision-making and profiling. Organizations must be prepared to respond to such requests within specific timeframes, typically 1 month. Failure to do so can result in complaints and enforcement actions. Upholding these rights is not only a legal obligation, but also central to maintaining trust with customers, employees, and stakeholders. Employees should be trained to recognize such requests and escalate them appropriately. Respecting individual rights is a direct reflection of an organization's commitment to privacy and accountability. These principles underpin every aspect of data processing and should be embedded throughout the organization's culture and operations. Organizations should treat these principles as the foundation for building effective privacy frameworks. From the initial design of systems to ongoing data management practices, each principle plays a critical role in safeguarding personal data and complying with the law. A solid understanding of these concepts prepares teams to make informed decisions, avoid regulatory breaches, and respond confidently to data protection challenges. As we progress through the course, each of these principles will be expanded upon and applied to real-world scenarios and organizational contexts. You have now completed Element 1 of the GDPR course. You will now be given 5 knowledge questions on this particular element. You must pass with more than 80% questions answered correctly in order to move on to the next section. Good luck!